The big development from the Supreme Court, giving its verdict in the appeal made by Zakia Jafri and the appeal against the exoneration of Prime Minister Narendra Modi in the 2002 Gujarat Riots case by the wife of a Congress MP who was killed in the violence is devoid of merits, is what the Supreme Court has said today, upholding the clearances issued to the then Chief Minister of the state by the SIT. The top court has dismissed the petition filed by Zakia Jafri, wife of Ehsan Jafri, who was among the 68 people who was killed in what came to be known as the Gulbarg Society massacre, one of the worst instances of violence and killings during the communal riots that took place in Gujarat in 2002. Well, let's go across to Sukirti for more. Sukirti, tell us more about this entire plea and today the Supreme Court finding it devoid of merit.
Well, yes, that is what the Supreme Court has said while dismissing this plea by Zakia Jafri. It has said that the appeal is devoid of any merit and it is dismissing this appeal, and that by doing that, the Supreme Court has upheld the clean sheet that was given by the SIT earlier to several accused, including then Gujarat CM Narendra Modi. This is significant because this is a huge matter that has been in controversy for the last 2 decades, and now Ms. Zakia Jafri has been, it's a setback for her from the top court of the country. As far as arguments in the Supreme Court are concerned, her lawyer, Kapil Sibal, had argued in court that the SIT that was probing the matter did not go through crucial evidence. It did not go through phone records. It did not seize several mobile phones. It did not go through several key documents. It did not go through several sting operation tapes that were conducted by Tehelka. All of that was not probed by the SIT, and that is why a probe is needed now to get into the allegations of a larger conspiracy. Kapil Sibal had also alleged that there was collusion between the police officials as well as the administration officials when it came to the Gujarat riots, and the administration failed in acting on time. However, the SIT as well as the Gujarat government had dismissed all of these allegations in court and had argued with Mr. Mukul Rohatgi representing the SIT in court, saying that all the probe was done in an efficient manner and all the evidence was thoroughly probed. There is no larger conspiracy when it comes to the Gujarat riots. Tushar Mehta, who is appearing for the Gujarat government, he had argued that all of this is just an attempt to keep the pot boiling. Those were his exact words, and he had said that if a probe started now again, it would be a travesty of justice. So that's as far as the arguments were in court. But for now, a setback to Ms. Zakia Jafri and a release to the SIT, which had carried out this probe for several months and then given a clean sheet to the accused.
All right, so that is the big news coming out from the Supreme Court, where the court has found devoid of merits that plea by Zakia Jafri, which was an appeal against the exoneration of Prime Minister Narendra Modi in the 2002 Gujarat riots. Well, to talk more about this, we're joined by Ashwini Dubey, advocate of the Supreme Court, and Kapil Madan, advocate also of the Supreme Court. So, Ashwini Dubey, now with the dismissal of this plea and, finding no merits in the plea that was made before them, do you think this finally lays to rest the whole conspiracy angle that has been alleged in the Gujarat riots?
Yeah, thank you, Gargi, for having me here. Gargi, yes, after this three-judgment judgment of today's Honorable Supreme Court, and after taking into consideration the SIT report and its closure report filed before the magistrate, the Honorable Supreme Court decision has put this case to rest. But now the question here is that the case was already decided by the SIT. Supreme Court appointed the SIT. SIT in its 351 pages report has found that the Prime Minister Modi has made every effort to ensure the law and order situation should not be deteriorated in the state, and there was no allegation found in the SIT report. But this matter traveled here. From the beginning, it was smearing that there were allegations which were politically motivated, accusing the Prime Minister Modi, and it was argued by the side of Prime Minister Modi that after certain years, after 4 or 5 years, this matter has come up, and then when everything is over. So what I think that now, after the Honorable Supreme Court has agreed and have found that the SIT report was on the basis of the finding of the facts, on the basis of the evidences, and there was no role attributed of Honorable Prime Minister and other 62 others, or direct or indirect involvement in the communal rights. And SIT has established that any of the persons listed in this Jafri's complaint have not been found to be involved in this alleged crime.
Right, Kapil Madan, your view, because, so many cases were filed after that, even when the SIT investigated the entire matter, and that was under the directions of the Supreme Court. There had been so many allegations about, records disappearing, etc. So, it's been fairly long and very messy, the entire investigation into how in 2002 you had, this violence raging, these communal riots taking place, and somebody like Ehsan Jafri, who was a former member of parliament, making call upon call, and still his society, Gulbarg society, being attacked and 68 people being killed that day.
Well, Gargi, look at this, this incident pertained to year 2002, and we are now in 2022. So 20 years have elapsed. And if you look at the historical background of this entire litigation, Zakia Jafri filed a first complaint on 6th of August 2006 before the DGP alleging a larger conspiracy. It is a matter of fact that there was a SIT appointed by the Supreme Court, and the SIT, gave the clean sheet to Mr. Narendra Modi. However, Zakia Jafri was not convinced, she was not satisfied, and she was availing her remedy recourses available to her as per law. Now, since the Supreme Court has also dismissed the petition alleging that there is no merit, I think, this matter has finally led to rest. The only scope available with Ms. Jafri is to either file a review petition, and I would very candidly say here that the jurisdiction in the review petitions are also very, very limited. You need to show to the court that there was an error apparent at the face of the order, and which has led to substantial injustice to any of the parties. So that's the only recourse as per, at this point in time available to Ms. Jafri. And otherwise, I think this matter has, attained finality.
And whether she would want to even pursue it, given her age, and as you said, 20 years have also gone by, and clearly we'll have to wait and see, but it does seem the end of her plea before the Supreme Court in the matter involving her husband. Thank you so much both for joining us.